And some government representatives have been chatting on a regular, semi-regular basis about ways to fix or address the cross-border data request problem. The problem of law enforcement in country A seeking access to data about a crime in their country when the data happens to be stored in another jurisdiction. If that regime is going to be fixed, what principles ought to address it? And we have come very close, but not quite all the way, to achieving a consensus about core principles that should inform that process. So I would love to hear, part of the reason for this panel is to hear from new voices about key issues, key principles that should inform the reform of the cross-border data request regime, and also to share a bit about that process that we've been through. So, and I think my colleague Jen is going to tell you a bit about some of the problems that give rise to the regime that we have now.
Thanks. I was also, I was told to instruct you all that if you want to ask a question, which will appear up here, you can do that at slido.com, and we will be able to answer your questions in the Q&A session. So we want this to be really interactive, as Andrew just said. Just as a brief summary of kind of where our process has ended up, we've been focused largely on the problem of foreign governments seeking access to content of communications that are held in the United States or by U.S. companies when the foreign government is investigating a local crime, a crime over which they have jurisdiction, and they are getting increasingly frustrated by the inability to access the data in any sort of expeditious manner. As I'm sure everyone in this room knows, but just to be sure, under current U.S. law, when that country is seeking access to the data, it has to make a formal diplomatic-to-diplomatic request via the MLAT system, and the process takes an average of about 10 months to get the data back. We, I think, collectively have been concerned about the negative incentives this creates for privacy and human rights, both in terms of an incentive towards data localization to facilitate the ease by which countries can get access to the data, increasing assertions of unilateral extraterritorial jurisdiction, like the kind that you see in UK law and the new draft bill that I think is the topic of a panel after ours, and other surreptitious means of accessing the data. And so part of what we've been trying to do is figure out if there's a human rights and privacy protective way to relieve some of that pressure, but also ensure that the baseline norms are still protected. And just the general approach that we've put forward is one in which companies would be permitted to enter into agreements with the United States if they met certain baseline human rights standards, and if their request mechanisms meant a list of human rights and privacy protective standards, then they could make direct requests to US-based companies for data in the investigation of crimes for which they have jurisdiction when the data that they're seeking is about persons who are not located in the United States and are not US citizens or legal permanent residents. That's the basic approach we've been pursuing. At the same time, the United States and the UK have been, the governments have been talking about a similar type of approach as well that I know will come up in the course of this conversation. So with that said, I want to turn it over to our panelists. We are going to do this very informally and let each panelist introduce him or herself, their name, where they're from, and then they're each going to speak for about 3 to 5 minutes. It's a really, we feel really lucky to have this opportunity to hear from a range of foreign perspectives. As I've said, our process has been largely US-centric to date, so we have a really great array of panelists, and then we will open it up for a discussion.
Introductions first, right? KS Park, OpenNet Korea.
I'm Elena Hickok from the Center for Internet and Society, Bangalore, India.
I am Denis Antoniali from Internet Lab in São Paulo, Brazil.
And I'm Bertrand de la Chapelle, Director of the Internet and Jurisdiction Project in Paris, France.
Great, KS, do you want to get started?
Yes. So the idea is to the idea is for foreign governments to be able to access the content hosted on U.S. servers without obtaining, without going through the U.S. Judicial procedure, including probable cause standard. So some people don't like it, but I call it AMLET bypass because it bypasses the AMLET procedure. I think it is just too early to talk about bypassing AMLET because we don't know whether AMLET can be fixed in the current setup. For instance, people talk about 10 months worth of backlogs, but let's look at, for what crimes those data requests are being made by the foreign governments. Some for national security law violations, some for assembly and demonstration law violations, some for, union-related crimes, some for blasphemies, some for, in the case of in a recent case with the Facebook, for insulting the president. I mean, these are the crimes that we should not be so worried about, not being investigated, right? I mean, is it really urgent to make sure that, all those data requests are filled efficiently, quickly? I mean, if we need to reduce the backlog, maybe we should first, survey what requests are being backlogged and just prioritize those requests that we think are for legitimate substantive crimes under international human rights law. And is it legitimate, right? I think that the principle that AMLET protects is the principle that the officers issuing warrant are somehow politically accountable to the people who are being subject to the search and seizure executed by that warrant. The officers, only then those officers will be sufficiently caring for the privacy of the people being surveillanced or searched and seized. I mean, you cannot imagine that, for instance, to search a home in Korea. I mean, would you agree that getting a warrant issued by a country in West Indies will be sufficient? I mean, there has to be some political nexus between where the surveillance is taking place and the political loyalty of the person, the political loyalty of the official approving that surveillance. That's the principle that AMLET is trying to protect. And that, whether that principle is sustainable or not in this digital age is a big question. It takes, I think, many years of discussion. I mean, I'm not like 100% in support of a principle that, this lawsuit that Microsoft is engaged in. I'm not 100% in support of Microsoft position, absolutist position that the data located in some country, no matter where they are, it should be access to the data should be approved by judge of the locus of the data. But I don't know whether the reverse is true. There is a big constitutional question here. So whether it's legitimate, I don't know. Whether it's legitimate to bypass AMLET, I don't know. And the third thing is it a good bargain, right? Think about the people living under authoritarian regimes that rely on the U.S. servers as their communication channels. The reason that Gmail can be popular in Korea is because people within Korea can communicate with one another, safe from overbearing surveillance and censorship from their domestic government. I mean, not just and it's not just about people living under authoritarian regimes. People around the world should be able to choose through which server they'll communicate with. And servers in different countries will be subject to different surveillance governance regime, but people should have their choice. That's the gift that the internet gave to us, that people can use different platforms to communicate one another. And you are throwing away that bargain if AMLET is bypassed so that the foreign governments can access the data of other countries without procedural safeguards of that country. Finally, I mean, this AMLET bypass is proposed as a means to ease the pressure for data localization, but I think we should not be so naive about the motives, incentives behind data localization. The countries that want to do data localization, their incentives are much greater than, being able to access some data on the U.S. servers. China just instituted strict data localization rule last month. I don't think China would reverse that just because now they can get data on the U.S. servers without going through AMLET procedure. So is it legitimate? We don't know. Is it a good bargain? I don't think so. Is it urgent? We don't know unless we look at we vet all these data requests. Will it achieve what it's supposed to, easing the pressure for data localization? I don't think so. I mean, I think the government's infringing on human rights. They are doing it for much more substantive, heavy socioeconomic reasons than just getting the data on U.S. servers without warrant.
Okay. This is a very interesting topic, and it's hard to pick where to choose, but perhaps I'll just quickly talk a little bit about the Indian context. So data can be requested across borders in India, either hopefully through a direct contact with the company, that's always tried, or through the IMLAT process. And there is a lot of frustration in India with the current IMLAT process, and I think, the research that both you and Andrew have done has done a really good job in documenting some of the issues with the process in terms of structural understandings as well as education or the need for education for law enforcement. So some of the results of the frustration in India has been, of course, requests for data localization, and I think the government does take this pretty seriously, considering it's ended up in the 12th year plan as a goal to push for data localization. In fall 2015, there was a draft encryption policy that, among other things, mandated users to store unencrypted copies of encrypted mails for 90 days. And this was retracted from the government, but it was a scary glimpse of what the government was planning for us. And India already has very low standards for encryption. Bulk encryption is not permitted up to 140 bit. Not permitted over 140 bit. We've seen the government try to pressure companies, or both informally and legally. There was the whole BlackBerry scandal where the government was asking for BlackBerry's keys to the content, BIS content, and we've heard sources tell us that actually officials, when they send IMLAT requests, they exaggerate what's happening, the crime, to try to get the attention of officials in the U.S. and hopefully that would, mean that it would go through the process faster. So I think there are some clear affirmities that need to be fixed. In terms of I would agree with what you said in terms of the need for research. We definitely need more research into what's going on in the MLAT process, both to fix that process and also to make sure that those same problems don't replicate themselves onto a new proposal. I could easily see misunderstandings or the law enforcement not knowing how to solve a problem happening again in another system, and that would be too bad. I think we also need to think about a new system being a way into encouraging regimes that are not up to snuff to really push for to really reform their provisions rather than just backing out and again pushing for data localization. And within that, I think strong transparency requirements are going to be necessary. I also have to. I think it's important to think about potential unintended consequences on companies. From what I've seen of different proposals, it seems that it could easily put the companies in the line of fire even more than they already are. And that's going to depend on how a company is able to say no and then what the government can do to that company after they say no. So I have a lot of thoughts, but I'll just start with that and we can take it from there.
Great. So this is a fascinating topic, and a lot of issues come up when I talk about it, but I'm just going to very briefly talk about the context in Brazil, and also I kind of feel compelled to comment on the WhatsApp cases, and because I also think that they're a very good snapshot of the consequences that might come out of those situations and the problems with the MLATs. So in Brazil, after Snowden, we were discussing our Marco Civil, our Internet Bill of Rights. And at that time, as one of the narratives around the problem of surveillance, especially by the U.S. government, made Congress try to implement a provision in Marco Civil about requiring data localization. That provision was dropped, and in exchange, what was implemented in Marco Civil was an extraterritorial jurisdiction rule, which basically says that if one of the devices is in Brazil, so basically if one of the users is in Brazil, Brazilian law applies. Marco Civil also puts forth some sanctions that might be imposed to companies, especially companies that are not solely based, that are not based in Brazil. Those consequences might go from fines to temporary or permanent blocks of applications and services. And this is exactly what happened in the WhatsApp cases. So I think the first thing that I have to say is that all these cases are criminal proceedings and they are under seal. So a lot of what has been said and the discussions are sometimes like speculations about what the cases really are. We don't have data, we don't know what kind of information was being requested, but in a nutshell, law enforcement was requiring access to data from WhatsApp, possibly the content of the communications. We don't know if they were asking for wiretapping, like future communications, or just access to communications that were already stored. But they wanted, from what we know, access to the content. And after the refusal of the company to provide that information, 2 court decisions last year demanded WhatsApp to be blocked in the entire country. The first one was reversed even before it was implemented, but the second one was implemented and lasted for about 12 hours before it was reversed. So that got a lot of attention, of course, because the users were angry, but that I think also shows that the judges get really frustrated when they can't get hold of the information. And just a couple of weeks ago, Facebook's vice president for Latin America was arrested in Brazil, also because of the same problem. And Another thing that I want to talk about that I think wasn't mentioned here yet is the discussion about encryption, because I think that brings a new element to the discussion, which is when the companies are not able to provide that information because it's just, well, that's what WhatsApp alleges, that it uses encryption and they just don't have access to the content, and so they can't provide it. So that is also something that we have to consider about a technical possibility of honoring those requests. And I also think that cooperation agreement are the only long-term solutions that can be put in place. As we have been saying, that there are a lot of problems with the MLATs, there are new solutions, but I think that it's incredibly important when we are thinking about those cooperation agreements not to leave privacy protections behind. All those mechanisms might empower surveillance, might give more surveillance power to these states. And we know, talking specifically about Brazil, if we look at the transparency reports from Google or Facebook, Brazil is usually one of the countries that has the most requests. So that is also something that would be important to consider when thinking about those frameworks where you facilitate access to those information. So I think those were my initial remarks. And
Okay. What I'd like to do is to highlight the following. This issue of cross-border access to user data is reaching a level of visibility in the recent months, actually, and it's important to understand why. The evolution that has taken place is that when you talk to law enforcement, most of the investigations that are conducted now rely on elements of digital evidence because of the considerable amount of data that is being stored by the companies. That's point one. The second element is that because a lot of those companies are actually located in different countries than the place where the alleged situation has emerged, there is a cross-border dimension to those investigations and those requests that was not as important in the past. And so the reason why the MLAT system is on the verge of being broken or is not functioning correctly is because it was initially intended for relatively rare exceptions where there was an actual connection, physical connection between the different countries and so on. And this mechanism is probably, it's worth to qualify it as, this is a switch network of international cooperation. It is basically a series of bilateral agreements that put in place a lot of procedural guarantees, and there are procedural guarantees, but the system itself is hardly scalable if you want to have something that works worldwide and that works expeditiously, and with sufficient guarantees that are balanced, because there is a strong asymmetry at the moment, and it is the third trend that we're confronted with. So you get the increased digital evidence, the cross-border nature, and the third element is that there is a strong situation of the relation with the companies that are based in the United States. And so this leads to a particularly important element in this discussion, which is the interpretation of the Electronic Communications Privacy Act, because this act makes a distinction between different types of data that can be accessed through different procedures. In particular, there's a strong distinction between content and non-content data, knowing that the content data cannot be provided voluntarily by companies to a foreign entity, a foreign public authority that requires it. And that on the contrary, the non-content data, including what is called basic subscriber information or traffic data, could potentially be provided voluntarily by the companies, which brings, of course, the big question of what are the criteria that the companies adopt, what is the leverage and the discretion that they exercise. So I think it's very important in this landscape to understand that the problem is growing and that it requires a solution because of the frustration. It's not only because of the threat of data localization, but it's one among others. because we need to find this to have appropriate modes of cooperation to solve actual crimes in certain cases, but that it is extremely important to have procedures that are respecting due process and even putting in place due process even better than what it is the case today. So I won't get into details. I just want to highlight this distinction between the three elements: access to basic subscriber information, access to traffic data, and access to content. In other words, to simplify, basic subscriber information for an email account, for instance, is who is the owner of this email account, what are the IP addresses that he or she has logged last from. Traffic data is the to and from in the email, and content is actually what you say in the email. What is extremely important is to get the facts right regarding, for instance, the proportion of requests that deal with basic subscriber information versus traffic data and versus content. Part of the work that has been done in the group to which Jennifer and Andrew are participating in is related to the third part, access to content data across borders, particularly in situations where the only nexus of connection with the United States is the fact that an online platform from the United States is being used, but all the rest is located in another country. Like victim, perpetrator, the public authorities are in in Europe or elsewhere, and it doesn't concern a US citizen. What you need to know is that in parallel to this activity that is developed in the US, among a certain number of actors, there are discussions that are taking place in Europe, and particularly the Netherlands, the Dutch presidency of the European Union, has convened a month ago a meeting in Amsterdam, convening the prosecutors and the ministries of justice of the 28 countries of the European Union to discuss this question of access to user data across borders. And the large American companies were invited to participate in this discussion because it is also a problem for Europe on the other side to see how it can handle this. I want to finish by saying what is fascinating is that those discussions are taking place in both directions, in both spaces, in Europe and in the United States, with probably not enough connection between who is discussing what, participating in both processes. I see that the angle for analysis is not exactly the same. And I'm particularly happy, actually, that there's perspective from India, Brazil, and Korea, because this is not a purely transatlantic problem. It is something that needs to be scalable. And if we don't engage actors from at least a few of those countries, it cannot be everybody from the onset, we will not have something that is correctly scalable. With that, I finish, and we can discuss further.
So thank you. I just want to spend 2 seconds just explaining in a little bit more detail the kind of the proposal that's been on the table today, both amongst the members of the group that we've been working with and also put forward by the U.S. with the U.S.-UK agreement, just so that people who are in here walk out with an accurate understanding. It's the agreements that the U.S. would like to see go forward would be limited to situations in which the U.S. entered into a bilateral agreement based on some sort of certification that the country met certain human rights standards. And from my understanding, the agreements also would carve out, would preclude foreign governments from making requests in situations that would violate speech norms as applied in the United States. And so I think some of the concerns that K.S. Park mentioned are addressed to some extent by precluding agreements with the kinds of repressive governments that K.S. Park mentioned. On the other hand, as you also pointed out, that means that some of the localization pressures that we see from some of the more repressive regimes aren't addressed by this type of proposal. And so this type of proposal is meant, I think, to address localization pressures in countries that meet certain human rights norms and that could achieve the basic due process and human rights standards, but isn't going to solve the localization problems that you mentioned with respect to China and some other regimes. With all that said, I mean, I think one of the things that we've struggled with is trying to figure out what are the appropriate standards that countries must meet in order to make these types of requests if such a regime or such cooperation regimes are put into place. And so it'd be interesting to hear both from the panelists, and also this is meant to be a workshop type format. It ended up in a room that doesn't feel like a workshop, but it would be interesting to hear from the audience as well.
I mean, I predict I predict the problem immediately in effecting this AMLAB reform. So it will deal with data request on a person outside the U.S. How can an intermediary, I mean, what information do you have about a person to know whether the person is outside the U.S. or not, right? I mean, will intermediaries begin engaging in kind of a, racial differentiation of the users? I mean, we are, all of us are fighting so hard to protect anonymity or right to use the internet anonymously, which means a lot of times we will not have enough information to know whether the person upon which search and seizure is being done has any nexus to the U.S. or not. How about people going back and forth between the U.S. and other countries, right? And also, I mean, I think that one of the inspirations for this way of bypassing AMLAT comes from Section 2702 of ECPA, which allows non-content data to be released to anybody that's not a U.S. government. Okay, I think that provision was botched from the beginning, right? I mean, Korean law does not allow non-content data to be disclosed to anybody that's not a Korean government. Any intermediary who wants to release, any intermediary who wants to release non-content data has to get court approval, has to see a court approval before doing so. I mean, this reform is trying to equalize the treatment of content data to the treatment of non-content data, but that's like race to the bottom.
So we actually have a couple of questions that have percolated in, and we'll start with the most upvoted question, which is there a role? Can you all see it? You can, yeah.
Yeah.
All right. So, is there a role, Bertrand?
Yeah, well, actually, I was looking at the screen, and I wanted to pick on a few of them. The role for the Cybercrime Convention, the Budapest Convention, as most of you know, was drafted in the context of the Council of Europe, but is now, I think, ratified by about 48 or 50 states. There's one provision that was mentioned during the Amsterdam conference that I mentioned earlier, which allows the companies to provide information, potentially fundamentally basic subscriber information under Article 18C or 18B, I think, and that has not been codified sufficiently in the rules. So there are discussions in the Council of Europe that are starting. They think about doing potentially an additional protocol to the Budapest Convention. But of course, whenever you talk about the Budapest Convention, you get the geographic coverage, which is not a universal regime either. The European Commission is, of course, also involved in trying to develop rules. And one of the challenges and the main message is, at the moment, one danger is that there will be several initiatives starting from many different places that will not be coordinated. So all the issues that KS is raising, all the challenges of criteria is going to be handled from different perspectives. And I want to pick on one thing I forgot to mention, is that the core of this discussion is about the implementation of the criteria of territoriality. And the whole debate about, is the location of the server the determining factor, as is the case in the discussion between around the Microsoft case, most of the discussions at the moment are tending towards saying that probably it is not the relevant or the only criteria, and Dan Svanteson was here. I had the opportunity to present a certain number of comments regarding other elements of territoriality than the location of server, and if he wants to speak later, it might be good.
Just a side note about the Cybercrime Convention, the provision that Bertrand is referring to is interesting because although the Cybercrime Convention is generally concerned with cyber crimes, and the MLAT problem is concerned with all crimes for which there is digital evidence, the Cybercrime Convention also has a provision regarding non-cyber crimes for which there is digital evidence. So the argument is not just this is an instrument that might help in some small subset of cyber crimes, but rather this is an instrument that I think slipped into a cybercrime convention that now has significance.
And there's actually a working group on digital evidence within the Council of Europe for that.
Greg?
From the, can you hear me? Center for Democracy and Technology. I've been involved in this process. The way I look at it is this. Basically, in exchange for closing down that metadata loophole that's in U.S. law that allows the U.S. government to disclose traffic information to anyone that asks for it that's not a governmental entity in the United States, in exchange for closing that down, it would permit foreign governments to make demands of Google and Facebook and the other U.S. providers under the foreign government's law, swapping out the protections that are in the U.S. law for those that are in the foreign government's law, just for the countries that are chosen by the Department of State and the Department of Justice in the United States. That's what it boils down to. And the question is whether that's a good idea. U.S. law is really bad when it comes to surveillance of people outside the United States for intelligence reasons. U.S. law is pretty good when it comes to the way the MLAT process works. It's just like domestic demands for content. It's just like that. So they actually have to go in front of a judge. They have to prove probable cause, which is a relatively high evidentiary standard, and then only then can the information be released. So really the question is, do you want to swap out that U.S. law for the foreign government law when the demand comes from one of these countries with which the U.S. has an agreement? And just to end here, it's not just the nationals of that country that are affected. If there's a deal with the UK, for example, and there is a draft deal now within the US government, if there's a deal with the UK, the United Kingdom could make demands of Google, Facebook, and the other US companies for data pertaining to anyone, anywhere, not just the UK people. So you've got to kind of trust the UK law worldwide. Now you've got to kind of trust U.S. law worldwide right now because that's what effectively governs these demands. So that's the way to look at it. Do you want to swap out the U.S. law for the foreign law?
Any other questions from the audience?
But just quickly, also, as if the U.S. enters into these agreements with other countries, you're also going to start trusting other countries' laws as well, as they, if it looks like what the U.S.-UK agreement looks like, because suddenly UK can access UK nationals and anybody else's data, then India can access Indian nationals and anybody else's data, and so I thought that it was an interesting way of phrasing it within the agreement. So yeah, I just wanted to add that to what you were saying.
And I think that's where the initial vetting that Greg was talking about by the Department of Justice and State of the country and their procedures comes in. But the other key piece of this that we haven't talked about that I think is essential is some sort of assessment mechanism if this is going to work effectively.
No, actually, I wanted just to add to what Greg was saying. It is a fair characterization of probably the choice or the evolution that is explored. There's one thing that needs to be taken into account is that, to a large extent, the current system of MLATs, because of the asymmetry of the location of the technical operators in the US, de facto applies US law worldwide. Okay. That has two consequences. One is positive and one is negative. The positive one is if we consider, as Greg says, that the US standard, especially on speech and on a certain number of things, is extremely high, and even some actors in Europe are saying, we like this notion that the standard is very high, even higher than ours sometimes. It is extending the US protection worldwide. That's the positive part. The negative part is that it is extending US law worldwide, which is conceptually delicate, because if you apply this in the reverse, then when the Americans listen about the application of the European Data Protection Directive worldwide through the right to be de-indexed, doesn't seem to like a good idea to have extraterritorial applications. So just to frame the problem, it's part of the conundrum. How to find a solution that addresses the problem of there is a very legitimate inquiry in, let's say, Italy, between an Italian that has killed another Italian in Italy, and the data is actually in the possession of an American company, irrespective of where it's stored. Today, why should it be the US law that applies is one of the problems. If we say Italy, it looks nice. If it is a more repressive regime, we will say, oh yeah, but we want the US law to apply. So that's the bit of a conundrum that we're struggling with.
Well, I don't see much conundrum in the second issue. I mean, the fact that you are effectively exporting the U.S. protection is only because the U.S. probable cause standard for surveillance is higher than other countries. If European countries have a higher standard for surveillance, higher standard of probable cause, will be through MLAT process will be exporting the European standard, because we are talking about MLAT process basically requires two warrants, right? One from the server and one from the US, and depending on which one has a higher standard, that plays the role of the gatekeeping, right? So it's not really a conundrum. It just restates the fact that there is a differential probable cause standard between countries.
Testing, yes, okay. Sort of going to that differential standard question, and let's assume that the MLAT approach doesn't scale. I think that's worth actually talking about, ways that it might scale, but let's assume that that is true. Right now, looking at the example of the US-UK agreement, it fundamentally changes the game in two ways. It not only lowers the standard compared to the current MLAT process by allowing British law to dictate the standard instead of American probable cause, it also eliminates the United States government as the mechanism through which the requests are made and its ability to vet and approve those requests. If the issue with MLAT is scalability, do we need to eliminate both of those checks in order to address that scalability issue, or could we maybe just pick one? Relatedly, if the issue that we are hoping to address, in addition to solving crime, is the avoidance of mandatory data localization, bad anti-encryption mandates, or aggressive extraterritorial applications of law that ends up getting executives thrown in jail when they happen to visit the wrong country. Aren't we, in the US, isn't the US government negotiating very poorly if it doesn't actually demand that those things not happen in exchange for agreeing to a deal? Otherwise, why are we doing it?
I think you're asking a very interesting question, and I keep the formulation, which is it only a scalability issue, or is it another dimension? And I think there are both elements. Regarding scalability, there are two elements. One is the mere technical factor of having bilateral agreements, which are most of the MLATs. Not some are multilateral, but most are bilateral. And so if you want something that scales up to maybe not 190 countries, but let's say 100 countries, ultimately you have something that is 13 or 15,000 agreements to iron. So that's one scalability issue. The other scalability issue is the resources that are available in the administration to handle those MLAT requests, because it's a complex circuit, as you know. It comes in the US to the Department of Justice, the Office of International Affairs, makes a first analysis by asking a court, then it takes it, goes to the company brings it back. There's a second vetting for the question of speech issue and so on. So it's burdensome. And so this second question is, can this be streamlined in a certain way, not necessarily changing the different steps, but I would say that is basically a process reengineering type of question. And structuring this so that it's more in electronic format, it is actually today already more, from what I understand, in electronic format than most people think. In many cases, we present the MLAT request as coming through the diplomatic pouch with the big seal and so on. It's actually not so caricatural. There are still some elements of that. But developing formats for MLAT requests, making sure that there are criteria for all the elements that should be put into the MLAT documents is a way to speed those processes and check the boxes in a better and more predictable manner. But the other question is unsolved. The other question is typically introduced by the fact that in certain cases, the only nexus of connection with the US territory is the use of a US-based platform, and all the rest is not there. So the conundrum that I was mentioning before is still there, irrespective of the scalability, I think. That's the way I perceive it.
I just want to sort of briefly put, and I'm not an expert on MLAT and these procedures, but just a little bit of comparative comment from someone who works a lot in the area of what the fourth comment addresses here, which is private actors. I've had a number of cases where I've represented speakers from international speakers who have spoken on American platforms anonymously and then been the subject of lawsuits with regard to speech. I've also, from the ISP side, dealt with the law enforcement subpoena issues domestically. And so just because you were asking the question, sort of what should we be looking at and thinking about in this process, keep in mind that in the domestic side, on the civil side, first of all, the United States, both by statute, the U.S. Speech Act, but even before that by numerous court decisions, had no problem saying we as an American court will not, as a matter of comity, apply the standards of some foreign jurisdiction as an exception to our normal rule of comity. When American speech is involved, we will not, for example, enforce judgments, et cetera, and that's now been codified in federal law. So if you think of that as the analogy, remembering that by the same token, in American law, anonymous speech is a constitutionally protected activity. When you also consider that the engineering you were just talking about, the process you're looking at here is ultimately an ex parte proceeding where ultimately some judge is being handed a bunch of stuff which may be crap or not, but the person who knows whether it's crap or not never finds out what's being said about the issue and how they might rebut it. I mean, in the civil context, a subpoena issues, the person, wherever they may be, if they're fortunate enough, and it's extremely rare to find a lawyer, may actually be able to go into court and rebut everything that's being said. The denial that this is a speech activity that may be contained in the materials may be rebuttable, easily rebuttable. The fact that somebody is, for example, a dissident or whatever, there's nothing to ferret that out in this ex parte proceeding as it's going through whatever process. So we can talk a lot about the protections that are there, but let's not exaggerate how great they may be and how there's sort of a process problem that needs to be solved here to speed up what may ultimately not be such a benevolent process. Lastly, well, I'll leave it at that. I'm sure there are other people who can comment on that.
No, I think that, I'll just make two comments. One, I don't think this is an either-or proposition. I think whatever if something like this were some sort of new cooperative agreements were to go forward, there is also a separate and independent need to improve, streamline, make better the MLAT system, because a whole lot of requests are still going to be employed through that system. But your last point, I think, is an important one, and that, yes, there are certain aspects of the MLAT system and the probable cause standard that are really kind of the gold standard. But there's a whole lot of things that aren't. And so, as you point out, there is no notice requirement. And it is possible to conceive of cooperative agreements that include notice requirements or include durational limits that don't exist or aren't required under the probable cause standard. So I guess I just wanted to emphasize that I think there's an opportunity here, and there's an opportunity that can be lost, because at this particular moment, the United States happens to have a lot of leverage because of the fact that so much of the data is held on US-based platforms. And so the United States has an opportunity to negotiate with foreign partner countries who are interested in expedited access and to use that leverage to raise standards. And at some point, that opportunity is not going to be here anymore. That's my perspective.
Yeah, I just wanted to say, I think there's a link actually between the question. There's often, I've heard this question asked a number of times, isn't there just a way to speed up the MLAT process? And if you look at it, you will inevitably come to the conclusion that the reason it is slow is the double lock mechanism that Kevin just described. It is the case that some of them are in diplomatic pouches, and yes, they should be digitized, and yes, we should have a standard form and all of the rest, but that at most is going to take a 10-month process and reduce it down to 5 months. In an ideal world, it's still a huge amount of work, because you have to satisfy a domestic legal process, and then it has to be transmitted through appropriate and official channels to a state that is not necessarily incentivized to handle it expeditiously, because it's not their law enforcement operation. And then a lawyer has to review it. I mean, if you talk to DOJ about these MLAT requests, they say, sure, computerize them. That'd be great. That would help, right? But at the end of the day, it's a lawyer who has to sit down and read the request and review it and make sure it's legit and then carry it over to a judge to get the warrant. I mean, that is a timely process, time-intensive process that is often not timely. The single best way to speed up the MLAT process is to not require it to go through 2 sets of government authorizations. Country A, there's a crime in country A, and in order to get the evidence to the crime, in fact, almost every crime, there's some digital evidence now, you have to satisfy process in country A, go through a diplomatic channel, and satisfy process in country B. No one would ever set up a system like that ex ante. It's just a legacy of the fact that these companies are all American or largely American and can claim that the evidence is all outside of the country where the crime has happened. So then the question is, if you don't like the privacy policies of country A and the companies are all based in country B, what do you do? Do you get rid of that double lock? And if it means, does it mean getting rid of country A's procedures or country B's? What's the right outcome? And that's kind of what we're all trying to work out. Any other questions from the audience? Kevin has another. There's one in the front here. Did you have a question?
Thank you for sharing your thoughts about this very challenging topic. The Deskowood proposal takes the position that the U.S. at the end of the day has sovereignty over data, and that the U.S. Let's say, has the power to give the seal of approval to other countries' legislation in terms of their compliance with human rights standards. What is the best approach then to deal with countries that are very jealous of their sovereignty and that are not very much willing to take that position that they're going to have to be evaluated by the U.S.? I'm thinking about Brazil. We would be a country that would be very much interested in this fast process, but we are jealous of our sovereignty, as you can see with the WhatsApp cases.
Yeah, I'll say a brief word and then let Jen answer. I don't think, just to clarify, I don't think we think of this as starting from the premise that the U.S. has sovereignty over the data. And in fact, I think one of the biggest dividing lines between people who look at our proposal and say it's great and people look at it and say it's terrible is that they say is just a question about whether you think that there's a choice between the world we live in right now and an ideal world, or the world we live in right now and the one we are rapidly heading towards because countries are jealous of their sovereignty. I see Brazil looking at the broken MLAT system and saying, screw that, I'm going to fix it by mandating localization or a backdoor to encryption or whatever it is. And that stuff is all much, much worse, it seems to me, than a negotiated, principled, albeit different from American standards, cross-border data request regime. And then I'll let Jen answer your question.
I mean, I completely agree with what Andrew just said, and I agree. I don't think we take a position on the question of who has sovereignty over data, and in fact, I think that's one of the most important contested questions and unresolved questions. What we do is say, under current law, as it's been interpreted to say that U.S. companies that hold the data here or operate here cannot turn over content of communications without violating U.S. law. And we are trying to address how we can deal with that restriction in ways that reduce the kind of conflicts that you're talking about when another country also claims sovereignty, or really jurisdiction, not sovereignty, jurisdiction over the same data. And so one of the kind of longer term goals or hopes that if agreements like this went forward, that you would begin to have maybe a different understanding of what the jurisdictional hook ought to be over data, and maybe it should turn on things like the location of the user or even the nationality of the user, with the caveat that raises really hard questions about proof and anonymity, and there's a whole host of other questions that need to be addressed with that. But I mean, my personal hope is that we start thinking about other jurisdictional hooks other than just location of data.
If I may piggyback on this, and the physical location on the panel doesn't mean that there's one heavy supporter here and a complete opponent on the other side. As the Internet and Jurisdiction Project, we have no stake in one particular suggestion or another. What is important is that this topic is being addressed, and without portraying the landscape as a very bleak landscape in terms of trends, I want to insert two elements that you may be not familiar with. The current situation is that the MLAT system leads the US government to have a say in this loop. There are two trends that are going against that, apart from data localization. One is the fact that when a company sets up its offices for serving countries outside of the US, in Ireland, for instance, as Yahoo did, for instance, when they regrouped in Ireland, their offices that were previously in different countries in Europe. The change, for instance, for the French authorities is that they were asking to Yahoo France before, and once it moved to Ireland, they're now asking the offices in Ireland, and if they need to make a formal request, it goes through an MLAT according to the Irish law. So think about the location of a lot of the companies that are actually distributing not only their data centers, but their headquarters or regional headquarters, as being a trend that, irrespective of this problem, will be done for commercial and other reasons. And this will lead to the MLAT system not being the US MLAT system, but other MLAT systems. That's one trend. The second trend that I understood only recently is that there is an orientation from a certain number of prosecutors, and particularly in Europe, and you may have seen the recent decision of Yahoo in Belgium that went through 3 hoops, going to the Supreme Court, the Cour de Cassation in Belgium, and then back to the appeal system, then to the Cour de Cassation, then back to the appeal system, then again to the Cour de Cassation. And this led to the notion, which is the following: it has an enormous potential spread, which is prosecutors saying, I do not care where you are incorporated. The moment you are serving citizens in my country, I can serve you production orders, and you are under my jurisdiction in my country, period. And believe me, this can have tremendous appeal for prosecutors, because it is a very understandable reasoning. And it is not extraterritorial extension of sovereignty by projecting yourself outside. It says, you're touching my territory, my law, my rules, my procedures. So without painting a bleak outcome, the interest of this discussion and the benefit of having this overall mingling with the topic is that we need to be aware of what are the different trends at the moment and when is the right moment and potential window of opportunity for setting standards that might become spreadable and that are not depending on the United States preserving forever its current dominant position in terms of jurisdiction.
I just want to quickly pick on that and add that not only the prosecutors but also the judges get really angry, and I think that's one of the reasons why we have seen these decisions more and more in Brazil, fines and blocks and even the arrests. So.
And just to add to that too, there's actually it's not just that prosecutors are saying, here's a novel idea, you're operating here, you're going to play by our rules. It's that's the way it works with banks, and that's the way it works with retailers, and that's the way it works with oil companies. And so here come these tech companies claiming that because their data centers are elsewhere, they don't have to play by local rules. And the prosecutors cannot believe it, and neither can the judges. And that system's just not going to stay in place, I don't think, forever.
Okay, I'm not MC, but the time is up. I need to run to my next panel too. Yeah.
All right. Well, please join me, before you leave, please join me in thanking the panelists.